Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about computer searches. Cases that should have gone to the Supreme Court of Canada, but didn't. Mr. Terwilliger was charged with a number of offenses that happened online. And in the course of investigating those offenses, the police obtained a search warrant for his computers. And then when they received the computers, they delved deep into the data on those computers. And Mr. Terwilliger argued that there should be a different type of authorization to search and seize computers versus to search and seize the type of data that computers can store. And this case does raise a very interesting question. When originally the laws were drafted around search and seizure, it usually pertained to things that were readily visible. If you open a purse, you can see the contents of the purse. If you open a safe, you can see the contents of a safe. If you go into a house, you can see what is in the house. But when it comes to electronic information, a lot more is revealed when you're searching the actual data in the electronic device then would be revealed by just looking at somebody's home or looking in their bag or their purse or their safe. And this is where that additional privacy concern potentially arises. It's not just the files that are saved on the computer, but metadata in relation to those files, and even data in relation to things that have been deleted, or history of activity that a person has engaged in online, things that they've downloaded, websites they've accessed. You can learn a whole lot more about somebody's core biographical information from examining everything that is in their computer than you could probably these days from entering their home. And that's the crux of the issue. Mr. Terwilliger proposed that there should be a two-stage process where there's an authority to search the computer and seize the computer, and then a secondary authority to go further into the type of activity that gives a broader picture than what is just saved on the desktop of the computer. And unfortunately, the Supreme Court of Canada didn't recognize the very significant privacy interests that arise here, which is odd considering they recently decided the case of Bajkovic, where they did say that you have a privacy interest in information related to your IP address and IP tracking online. So their denial of leave in this case seems to be at odds with their otherwise recognition of the privacy interests that arise in online activity. Unfortunately, it will take another case and perhaps another case involving new legislation that's currently proposed before Parliament before the Supreme Court of Canada has the opportunity to revisit the issue of how much information can be searched when an electronic device is seized. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Please like, subscribe, and share with your friends.